Civil Procedure Code Practice Questions Session 13. In this session, we will discuss the questions that may be asked in Judicial Services examination. We help the students in preparation of Judicial Services examination through WhatsApp. If you want to receive regular updates, please send us your mobile number through WhatsApp on 8199898985. Question number 301. The counterclaim is to be treated as option A, separate suit, option B, a plaint, option C, both A and B, option D, none of the above. The counterclaim is to be treated as a plaint. So answer is option B. Option B is the answer. Question number 302. In any case in which the defendant sets up counterclaim, the suit of the plaintiff is stayed, discontinued, or dismissed. The counterclaim, option A, shall be stayed, option B, nevertheless be proceeded with, option C, may be continued with the leave of the court, option D, no specific provision. In any case in which the defendant sets up counterclaim, the suit of the plaintiff is stayed, discontinued, or dismissed. The counterclaim nevertheless be proceeded with. So answer is option B. Option B is the answer. Question number 303. Mark the incorrect statement. Option A, in a counterclaim set up by defendant, the plaintiff cannot file a written statement. Option A is incorrect statement. Option B, a counterclaim can be set up only in respect of claim for which the defendant can file a separate suit. Option B is a correct statement. Option C, if the plaintiff commits a default in putting in his reply to the defendant's counterclaim, the court may pronounce a judgment against him or pass any other order. This is also correct statement. Option D, none of the above. So answer is option A. Option A is incorrect statement. A is the answer. Question number 304. Mark the incorrect proposition. Set off is a statutory defense to a plaintiff's action, whereas a counterclaim is a cross action. This is correct proposition. Set off and counterclaim arises out of the same transaction. This is incorrect proposition. Set off should not be barred on the date of the suit, while counterclaim should not be barred on the date of filing of written statement. This is also correct proposition. Claim for set off cannot exceed plaintiff's claim, whereas counterclaim can exceed the plaintiff's claim. This is also correct proposition. Both set off and counterclaim cannot exceed the pecuniary jurisdiction of the court. This is also correct proposition. So, answer is option B. Option B is the answer. Option B is the answer. Question number 305. Which order of the CPC provides for the interrogatories and inspection? Option A, Order 9. Order 9 deals with appearance of parties and consequence of non-appearance. Order 10, option B, Order 10. Order 10 deals with examination of parties by the court. Order 11 deals with discovery and inspection. Order 12 deals with admission. Which order of the CPC provides for the interrogatories and inspection? Order 11, heading Discovery and Inspection, provides for the interrogatories and inspection. So answer is option C. Option C is the answer. Question number 306. The main aim of the interrogatories is option A, to obtain information as to all material facts or documents relevant to the issue. Option B, to maintain one's own case. Option C, to rebut the case of the adversary. Option D, all of the above. The main aim of interrogatories is to obtain information as to all material facts or documents relevant to the issue. The main aim of interrogatories is to maintain one's own case. The main aim of interrogatories is to rebut the case of the adversary. So answer is option D. Option D is the answer. Question number 307. Mark the incorrect statement. Option A. In any suit, the plaintiff or the defendant may deliver interrogatories in writing for the examination of the opposite parties. This is a correct statement. Option B. The leave of the court is not necessary for the delivery of interrogatories. This is not correct statement. This is incorrect statement. Option C. The interrogatories are to be answered by an affidavit to be filed within 10 days or such other time as allowed by the court. This is also correct statement. Option D, none of the above. So answer is option B. Option B is the answer. Question number 308. The court, while deciding the application made for leave to deliver interrogatories, should consider: option A, that the interrogatories are necessary for the fair disposal of the suit. Option B, that the interrogatories are necessary for saving cost. So answer is option C. Option C is the answer. Question number 309. Objections to interrogatories could be made by a party if is: option A, scandalous; option B, irrelevant or not bona fide; option C, privileged; option D, all of the above. Answer is option D. Option D is the answer. Question number 310. The court may set aside an interrogatory on the ground of: option A, unnecessary or prolix; option B, oppressive; option C, scandalous or vexatious; option D, all of the above. The court may set aside an interrogatory on the ground of unnecessary, oppressive, scandalous and vexatious. So answer is option D. Option D is the answer. Question number 311. An application to set aside an interrogatory must be made within how many days of the service of interrogatories? Option A 8 days, option B 9 days, option C 15 days, option D 7 days. An application to set aside an interrogatory must be made within 7 days of the service of interrogatories. So answer is option D. Question number 312. At the trial of suit, any party may use in evidence. Option A, anyone of answers in reply to the interrogatories. Option B, a part of the answer in reply to the interrogatories. Option C, both A and B, but the court can look at the whole of the answer. At the trial of the suit, any party may use in evidence any one of answers in reply to the interrogatories, a part of the answer in reply to the interrogatories, but the court can look at the whole of the answer. So answer is option C. Option C is the answer. Question number 313. Mark the correct statement. Option A, the questions which are put only to test the credibility of a person will not be allowed as interrogatories, although they may be asked in cross-examination. This is correct statement. Option B, interrogatories can be administered only to a party to a suit or not to a witness, whereas cross-examination can be of any person, parties, and witness alike. This is also correct statement. Option C, a party filing affidavit in reply to interrogatories can neither cross-examine nor adduce evidence to contradict it, as it is a conclusive proof. This is also correct statement. Option D, all of the above, all statements are correct statement. So answer is option D. Option D is the answer. Question number 314. Question is, the discovery of documents is to be made by. Option A, an affidavit of documents. Option B, a particular of documents. Option C, both A and B. Option D, only A. So answer is option D. Option D is the answer. Question number 315. When does the documents are to be produced for inspection. Option A, at any time, at or before the settlement of issues. Option B, at any time. Option C, at the time of evidence. Option D, all of the above. When does the documents are to be produced for inspection? At any time, at or before the settlement of issues. Answer is option A. Option A is the answer. Question number 316. A party may object to produce a document on which of the following grounds? Option A, document relates to his own title. Option B, sufficient cause or excuse. Option C, privileged document. So answer is option D. Option D is the answer. Question number 317. The premature discovery under Rule 20 of the Order 11 implies. Option A, the court may order the discovery of documents despite the objection of a party and before applying its mind as to objection to determine any issue or question in dispute. Option B, the court may not order the discovery of documents. Option C, a party produces a document for the inspection of the other party before the settlement of issues. Option D, a party produces a document for the inspection of the other party despite not being given a notice to produce it. The premature discovery under Rule 20 of the Order 11 implies the court may order the discovery of documents despite the objection of a party and before applying its mind as to objection to determine any issue or question in dispute. So answer is option A. Option A is the answer. Question number 318. Order 11, Rule 21 provides that if any party fails to comply with any order to answer interrogatories or for discovery or inspection of documents. Option A, the court may dismiss the suit for want of prosecution if he is a plaintiff. Option B, the court may struck down the defense of the defendant. Option C, the party could be committed for contempt of court. So answer is option D. Option D is the answer. Order 11 deals with discovery and inspection. Order 11 has 23 rules. Rule 1 deals with discovery by interrogatories. Rule 2 deals with particular interrogatories to be submitted. Rule 3 cost of interrogatories. Rule 4 form of interrogatories. Rule 5 corporations. Rule 6 objections to interrogatories by answer. Rule 7 setting aside and striking out interrogatories. Rule 8 affidavit in answer filing. Rule 9 form of affidavit in answer. Rule 10 no exception to be taken. Rule 11 order to answer or answer further. Rule 12 application for discovery of documents. Rule 13 affidavit of documents. Rule 14 production of documents. Rule 15 inspection of documents referred to in pleadings or affidavits. Rule 16 notice to produce. Rule 17 time for inspection when notice given. Rule 18 order for inspection. Rule 19 verified copies. Rule 20 premature discovery. Rule 21 non-compliance with order for discovery. Rule 22 using answers to interrogatories at trial. Rule 23 order to apply to minors. Question number 319. Under Order 13, the parties are required to produce all the documentary evidence in original. Option A, on or before the settlement of issues. Option B, at any time. Option C, at the stage of evidence. Option D, none of the above. Under Order 13, the parties are required to produce all the documentary evidence in original on or before the settlement of issues. So answer is option A. Option A is the answer. Order 13 deals with production, impounding, and return of documents. Order 13 has 11 rules. Order 13, 11 rules. Rule 1. Original documents to be produced at or before the settlement of issues. Rule 2. Omitted by Amendment Act 1999. Rule 3. Rejection of irrelevant or inadmissible documents. Rule 4. Endorsement on documents admitted in evidence. Rule 5. Endorsement on copies of admitted entries in books, accounts, and records. Rule 6. Endorsements on documents rejected as inadmissible in evidence. Rule 7. Recording of admitted and return of rejected documents. Rule 8. The court may order any document to be impounded. Rule 9. Return of admitted documents. Rule 10. The court may send for papers from its own record or from other courts. Rule 11. Provisions as to documents applied to material objects. Question number 320. If a party does not file the documentary evidence in his possession under Order 13, Rule 1. Option A. The party is excluded from filing the same as a subsequent stage of the proceeding. Option B. The party is not excluded from filing the same at a subsequent stage of the proceeding but can file the same only with the leave of the court. Option C. The party is not excluded from filing the same at a subsequent stage of the proceeding but can file the same only with the leave of the court except documents produced for the cross-examination of the witnesses of the other parties or handed over to a witness merely to refresh his memory. Option D. None of the above. If a party does not file the documentary evidence in his possession under Order 13, Rule 1, the party is not excluded from filing the same at a subsequent stage of the proceeding but can file the same only with the leave of the court except documents produced for the cross-examination of the witnesses of the other party or handed over to a witness merely to refresh his memory. Option C is the answer. Option C. Question number 321. Mark the incorrect statement. The court may, at any stage of the suit, reject any document which it considers irrelevant or inadmissible. Correct statement. Option B. Every document admitted in evidence is to be endorsed. This is also correct statement. Option C. When a document is an entry in a letter book, show book, any other account, the court may require a copy of that entry and return the original. This is also correct statement. Option D. A rejected document need not to be endorsed at all. This is incorrect statement. So option D is the answer. Question number 322. The original documents which have been admitted in evidence. Option A cannot be returned to a party. Option B can be returned after the suit is over or appeal, if allowed, has been disposed of. Option C can be returned during the pendency of the suit if the certified copies thereof have been produced. The original documents which have been admitted in evidence can be returned after the suit is over or appeal, if allowed, has been disposed of. The original documents which have been admitted in evidence can be returned during the pendency of the suit if the certified copies thereof have been produced. So, option D is the answer. Option D is the answer. Question number 323. Which documents form part of the record of the suit? Option A. Documents filed by the party along with the plaint or written statement. Option B. Documents which have been admitted in evidence. Option C. Documents which have been admitted or rejected in evidence. Option D. All kinds of documents. Which documents form part of the record of the suit? Documents which have been admitted in evidence. So, option B is the answer. Question number 324. The impounding of documents by the court is provided under option A, Order 13, Rule 3, option B, Order 13, Rule 6, option C, Order 13, Rule 7, option D, Order 13, Rule 8. The impounding of documents by the court is provided under Order 13, Rule 8. So option D is the answer. Question number 325. What kinds of admission are provided under the CPC? Option A. Admissions in pleadings. Option B. Admission by agreement of parties. Option C. Admission on notice. So answer is option D. Option D is the answer. If you have any query, please feel free to contact us at legalbuddy@gmail.com. Thank you.